All right, we're going to get started here. Hi, everyone. Thank you for joining us today. My name is Taylor Bloom, and I'm a privacy attorney with Baker Hostetler. I also serve as the chair of the Ad Tech Subcommittee for the CLA Privacy Law section. Today, we have a really great event planned, which will cover the impact of CPRA on your digital advertising initiatives in 2023. We are really lucky to have Michael Hahn joining us today as our main speaker. Michael Hahn is the Executive Vice President and General Counsel at IAB and the IAB Tech Lab. Michael's responsible for all legal matters there, including the direction for legal strategy, privacy compliance, and general corporate matters. Michael's also responsible for advocating for the digital advertising industry on all the common legal issues affecting all of the member companies. Michael's going to present today, and I'm going to turn it over to him to lead this presentation. However, I will say that we are going to have some questions at the end, but if anyone has questions during the presentation, please feel free to put them in the chat. And if we have time at the end, we will try to get to them if we can. All right, Michael, it's all you.
All right. Well, thank you so much for inviting me today, Taylor, and welcome everyone. And thanks so much for spending your morning or afternoon with me, depending on where you're located. So today we're going to talk through how I see CPRA impacting the digital advertising industry, and it's really a systemic impact. It impacts the way you conduct your targeted advertising, the way you measure your ads, the use of sensitive personal information. It impacts the way you need to pass signals around consumer privacy preferences. So there really is some far-reaching impact. And in order to really have a fruitful discussion about the nature of the impact, it's important to equally think about how am I going to comply? And I always think that there are certain concepts we as an industry all need to get on board with in order to develop a solution, because we got to have the same starting point. And that begins with the first premise, which is sale is really broad. This is something that there was obviously a bit of disagreement about in 2019, and I think in the current state of the world, there really is no question about its breadth. I mean, we certainly said as IAB in 2020 when we conducted a survey of our members, I think it was approximately 70% of legal counsel thought the placement of a pixel on a publisher's page resulted in a sale. I think the enforcement actions of the California Attorney General's office make that clear. And then there was, this boogeyman issue, which is like, well, is measurement a sale? And I think now we have clarity. In one of the recent CPPA meetings, where the executive director referred to it as being a sale. And frankly, there's not a ton of intellectual distinction around what separates personal information that happens for measurement purposes as opposed to other digital advertising purposes, other than the fact that it probably has a more innocuous type of impact. The second premise that I think everyone needs to come to agreement on, which is, sharing does not encompass every activity that is involved in what is known as targeted advertising. Doesn't mean it's not also captured by sale, but not everything is targeted advertising, is a share for cross-context behavioral advertising purposes. So there's obviously no definition in the statute as to what it means to target. So you go with a dictionary definition. What does this mean in practice? Well, when you're on the buy side and you're activating a segment, that's targeted advertising. You're targeting consumers based upon their personal information. On the sell side, when the publisher sends the ad call to the SSP and the SSP discloses the bid request to the DSP for cross-context behavioral advertising purposes, right? those are typical activities that are associated with targeting. But when does targeting not occur? And the two clear examples, I think, are frequency capping and measurement and attribution. Those are activities, for example, that might occur with an ad that's delivered through cross-context behavioral advertising, as well as an ad that's not delivered through cross-context behavioral advertising. So that kind of indicates that it's not really, the term doesn't fit into that term targeting, which is built into the definition of share. That being said, while it doesn't constitute targeted advertising, it does likely constitute a sale. And we need to accept that baseline premise. It's not one that we can address and find a compliant way to approach it, but we do need to start with that premise in mind. Premise number 3 is that publishers and advertisers can jointly control the purposes and means of processing for certain particular purposes. If you're like me, you read with CCPA the definition of business at least 1,000 times, and you saw this language: alone or jointly with others controls the purpose, means of processing personal information, which comes right out of GDPR. Well, I certainly in 2019 had absolutely no idea what to do with that little piece of information. It was sort of orthogonal to the statute. I attributed it to the short time frame in which it was drafted. But now, as I begin to think more broadly and systemically about CPRA compliance and about some of the data flows, I think there actually is a good case to be made that there are certain activities that we should embrace being jointly controlled. And if there is a joint control for a particular purpose, let's say for measurement purposes, that an advertiser and a publisher both jointly control for that particular purpose, then the issue of combination gets treated differently. So we'll talk a little more about that. The fourth, I think, is pretty basic, which is that disclosure of personal information to a service provider or contractor. It's not a sale or a share by definition. So now I want to turn to, like, what are consumers actually going to be opting out of? So you go to a publisher's page, you go to an advertiser's page. The consumer is most likely going to see a button that opts out of sales and shares together. Maybe they'll also make use of that additional alternative provision in the draft regs that puts SPI in there too, which is like the ultimate opt-out. But assuming that it's at least the first two, let's not cloud the discussion here for the moment for purposes of this, that you're opting out of sales and shares. Well, what does that mean? Like, well, you go to the publisher's page and I'm opting out, which means they can't engage in cross-context behavioral advertising. Well, that basically means that, you should be able to be opted out from an ad being delivered because I appear somewhere in an audience segment. So like sort of matching my ID from this page to an audience segment that maybe sits with a DSP, or that there's some sort of, I'll call it third-party data that is going to get enriched with me to even more accurately identify me. The second thing that I might be opting out of, if I'm, for example, on the advertiser's page, is the advertiser audience segment. So I'm thinking in this context about retargeting or a custom audience. This type of activity is cross-context behavioral advertising. It's also a sale of personal information, right? if I have abandoned my cart and now I'm being put in a segment of folks who have abandoned cart for a particular type of product, and I've opted out of sale and I've opted out of sharing for cross-context behavioral advertising purposes, that's not an activity that one should reasonably be permitted to undertake in compliance with the law. But here are two other really interesting and somewhat complex scenarios that arise. So, not all advertising, obviously, is cross-context behavioral advertising, right? There's a real market for publisher audience segments. There's a market for contextual advertising, seller-defined audiences. Those types of audiences and targeting that happen do not fit the definition of cross-context behavioral advertising. But they do disclose IP address and perhaps some other personal information when the bid goes out programmatically through OpenRTB. And so if the consumer has opted out of sale and cross-context behavioral advertising, well, that's a problem, right? So many times people think, well, contextual is my solution to all. Well, it's not the solution to all because consumer just opted out of that sale as well. It might not be targeted advertising or cross-context behavioral advertising, but it is a sale. These are things that we can solve for with the right contractual mechanisms, but that is part of the challenge that is before us. We're also focused in thinking about what happens with ad delivery and reporting upon an opt-out. Well, when you're engaged in frequency capping, right, so that you don't see an ad 10 times, the advertiser might say, like, cap it at 3 times. Well, that requires the publisher to send your ID, and that would need to be about the delivery of that ad. It needs to be stored by the demand side platform. That's a sale. Measurement, same thing, right? There's personal information that is required to be passed in order for the measurement company to measure from, let's say, the click to view or whatever it is on the publisher side to the measurement company. And the same applies with conversion on the advertiser side. So if you clicked into that ad, personal information is sent from the publisher to the measurement company. You now go to the advertiser site, and there's a pixel there. That information then goes to the measurement company as well. So you've opted out of that too, both the measurement and the conversion tracking. For sure, there's an opt-out also when the consumer does this for optimization, right? So that's both a sale and targeted advertising. You're usually using this type of data and combining it together to develop models across that is based on information from across ad campaigns. So I think the impact is really a profound one. Additionally, there are obligations that go beyond, obviously, the opt-out request, and some of the real challenges that exist are around deletion requests, right? Deletions now not only need to be passed to service providers, but they need to be passed to third parties. If you start with the premise that, as the Attorney General's office has, that the pixel on page is likely to be a sale in the digital advertising context, and now you have an obligation to delete when there are sales to third parties, that is a pretty staggering amount of data that could be potentially subject to deletion. And then the question is, how do you figure out how to get to these third parties to whom the information has been, quote unquote, sold, or shared to delete. And this also is something that we are trying to work on at the IAB. And of course, there's the obligation to not only respond to opt-outs, they need to be forwarded on. And there are certainly obligations around global privacy controls. So now I'm going to talk for a few minutes about the IAB Limited Service Provider Agreement and what we're trying to do to address these challenges so that we can comply with the letter of the law, hew closely to it, and at the same time, try to preserve some of the basic functionality that I think the regulators want us to be able to do. I don't think they're looking for no ad to appear, right? Even if they want a contextual ad to appear. If you can't measure the ad, doesn't really do anyone any good because no one's going to pay for that which can't be measured. So let's talk about what the IAB Limited Service Provider Agreement is currently framed at right now before we get into what it could look like in the future. Right now, there are about 1,000 signatories to the LSPA, and it's principally publishers and ad technology companies. So when I look back at what we were trying to achieve back then, I think we sensibly recognized that at that time, advertisers were not necessary for purposes of the LSPA. So we created a contractual framework for the industry to sign on to, and that created certain reps and warranties that publishers needed to provide to the downstream participants, the ad tech companies who signed onto the agreement, required them to send signals using the US privacy string to effectuate consumer privacy choices, and also said, like, when the consumer opted out, that you could then deliver an ad in a much more constrained way as a service provider. But how do you do that in the complicated ecosystem that we have? If you are a publisher and you on your own went and you entered into a service provider agreement with your supply side platform, and then they send the bid request out to a bunch of DSPs who are not service providers, your service provider has now engaged in a sale. That would be a violation of the law. And so that was something that we were trying to address by saying these demand side platforms will have a privity of contract through the LSPA that follows the data, that creates that contractual relationship to cause the demand side platform to become a publisher, to become a service provider to the publisher. And I think it has worked out well. So now I want to turn to what we're trying to address as we focus on CPRA and how to achieve compliance. And in fact, what we're trying to do is achieve a multi-state compliance framework, which is in some ways even more tricky and challenging, but all achievable. So the first thing we're really trying to solve for, the biggest and most important thing, is measurement and frequency capping, right? Frequency capping is like a form of waste. Advertisers don't believe that they're getting value when you see an ad for the 10th time. And if anything, it could hurt their brand. And I'm sure consumers aren't thrilled with seeing an ad too many times as well. Likewise, we want to be able to ensure that measurement can happen as well. So when I think about the scenarios which highlight the challenges, like just take a contextual ad. A contextual ad has IP address at a minimum, but potentially even more, that flows through OpenRTB to downstream companies who are going to bid on that ad. that is personal information. So now the consumer's opted out. You can't even see a contextual, you can't see a contextual ad because it's not gonna, there's no way to measure it. So what is the pathway forward? The pathway forward is to ensure that there's a service provider agreement in place. Now, the challenge, of course, is scaling these service provider agreements, which is why we're going to be amending the LSPA to provide that baseline contractual relationship between, like, for example, the measurement companies would be able to be in privity with the advertisers who would be signing on to, as well as the publishers. But you know, that part is a challenge across, frankly, all of the state privacy laws, and one which is reasonably can be addressed. But CPRA poses an additional challenge, which is that it prohibits combinations by service providers. So this is where I go back to this joint controller concept. If the purpose of joint control, I'm sorry, if the purpose of the prohibition on combining personal information is to ensure that the information is not being used for multiple business purposes, whether to the benefit of the service provider or the different businesses, so that there are different business purposes for which it's being used, there's a prohibition. But what we're talking about here is two companies that have the same shared business purpose, which is to measure the same ad delivered to the same consumer. And that if you have engaged in a joint control relationship for that to be used for a single purpose, I would submit that that's likely not an unlawful combination of personal information. And folks have asked, how can you guarantee that? Well, I can't guarantee anything. I'm sure I will be having a discussion at some point in the future with the CPPA about issues like this. But I do think that this is a workable and reasonable framework. And like everything else, if you put a little dose of rationality and reason to it, then I think you're more likely to come out with successful outcomes. So when the consumer opts out, you also can't sell on first-party data because while it's not impacted by the CCPA opt-out, it is a form of sale. So you get into this odd place too, that the form of contextual ad or a publisher segment, right? A segment that, the publisher itself is going to sell. Let's say it's they've got an auto section on the newspaper's website where they write articles about cars, and they have a segment of users of auto intenders. That is not generated across sites such that it constitutes cross-context behavioral advertising, but as soon as you put it into out for bid, it's certainly a sale. And so what we would suggest through a process like the LSPA is that when there is an opt-out, if you want to be able to do contextual advertising or advertising on the publisher's audience segments, that we could do this through the service provider relationships. And of course, service providers are an exception to sale. Perhaps one of the biggest practical challenges that exists for CPRA is this requirement that businesses have contracts with the third parties to whom they sell personal information. And in light of the breadth of what constitutes a sale in the digital advertising industry, that is a real significant challenge. There are a lot of pixels on page, and this is really going to place a significant burden, but one that will need to be managed by publishers and advertisers. There were also some real technology challenges too. When I think about the pixels that are placed in the ad creative that gets delivered onto the publisher's page, those are going to be some of the most challenging situations that we're going to need to hopefully develop technology solutions for, because, they're, to prevent those pixels from coming onto page is a unique challenge. But what I would submit is the pathway forward is making sure industry participants are signed on to the LSPA so that they'll be contractually bound in those kinds of situations. I will note that there are some real privity problems that we have as an industry. I talked before about the publisher SSP DSP privity problem, that DSPs didn't have privity with the publisher, and we captured that in the first round of LSPA. Well, now that you've got to have a contract with a third party, what do we do about situations like in the ad creative, when it gets brought onto the publisher's page that there is a measurement pixel in there, for example, and that publisher typically doesn't have a contract with the advertiser's measurement company? What do we do about the scenario where the advertiser has an ad server? That ad server sends personal information to deliver the ad to the publisher's ad server. There are never any contracts. There have never been any contracts in those scenarios. The prospect of there suddenly being a whole host of contracts that are going to be written where the parties don't even know exactly who they are would be daunting, which is the only reason we could get the LSPA to serve as that sort of gap filler to enable the digital advertising transactions to happen. And in fact, when I think about advertiser liability, when I saw the draft regulations, I said, wow, there's a few things in here that makes one take a step back and say, that puts a new spin on it, right? So just when you thought you didn't have liability for the activities of your service providers or your third parties, unless you had knowledge or reasonably should have known that they were engaged in unlawful conduct, now you have liability unless you're doing due diligence. So just think about this, right? I'm an advertiser. I've got a third-party ad server. That ad server has never had a contract with a publisher ad server, does not know where to start. I now need to do diligence of them. Otherwise, I have liability for something that I know doesn't exist right now. I don't know. So it keeps coming back. Like the only answer is going to be like that we could come up with is signing on to an LSPA so that advertisers can encourage their ad servers, publishers can encourage their ad servers to sign on. And then there's contractual privity between both sets of ad servers. Other problems we're working on solving for is signaling. When I look at the US privacy string and its quaint, 5 or 6 slots, that is the technical specification that's used when you come on to, let's say, a publisher or advertiser's page, and the consumer elects to opt out on the publisher's page. If there's a signaling mechanism that industry participants build to propagate that signal so everyone downstream understands what that election is. We are in the process of drafting a multi-state signaling methodology that will be encoded into a long string within the IAB Tech Lab's global privacy platform. So the IAB Legal Affairs Council has been working on what I'll call the legal inputs as to what the slots should mean under each of the applicable laws. And now the engineers pick up the work and say, how do we turn this into a technical specification so that industry engineers can help build to it, so that one day when you get to the publisher or advertiser site and you have your CMP, that they will propagate that signal. We're also working on a deletion specification. So that's one of the things that I talked about earlier, is that, if there's a deletion request and you've got all these sales that happen to third parties, how do we possibly manage that? And there is no way to manage that without a centralized specification that everyone can build to and start using a common language. I'm going to take a few minutes and share some thoughts about the draft regulations and what I think their impact is. I'm certainly not going to go through all the regs or all 65 pages of them and their statement of reasons, but I'm going to highlight a few of them that I think have some real significant impact, and then we'll move to questions. So first is 7002. So this was one of those ones that made everyone, I think, lean back in their chair saying, huh, didn't know that. This is a new way of thinking about things, that when you collect and use personal information, you now need to get consent if it's not consistent with the average consumer's expectations. So I think it was incredibly helpful that the CPPA provided examples of what is not consistent with an average consumer's expectations. I would submit that we need a lot of examples to provide parameters around this. But I also think back to the development of antitrust law in the early 20th century as to what constituted an unreasonable restraint of trade. It took decades to ultimately develop what was unreasonable. I suspect that while we're going to get, hopefully, even more examples of what is consistent with an average consumer's expectations and what's not, that this is going to be a concept that evolves with the law, assuming that it makes its way into the final regulations, which I strongly suspect that it will. Notice at collection introduced a new concept, which is that third parties that control information is a new term that is being used. So that if you're, let's say, a publisher or advertiser, you have a pixel on your page. Let's say it's a measurement pixel or some other form of analytics. That third-party pixel, you have now sold the personal information to, let's say, that analytics company. They are also deemed to be a third party that controls the collection by virtue of their pixels. So there's a sale, but they also control the collection. And now you either A, need to name the third parties that control that information, or you need to provide information about their business practices. This is an area where I sincerely hope that we gain more clarity as the draft regulation process unfolds. I think there's probably sensitivity by some about identifying the third parties that control, and that most folks will probably want to go to the alternative. But I think there's also some real practical challenges, like when the ad creative is delivered onto the publisher's page, you actually most of the time don't know who all of those third parties are until they show up to the party. So there's going to be some interesting challenges to get our arms around, both technologically and otherwise, in order to comply with this. But to focus for a moment on this alternative language about information about their business practices, I don't understand what this means. So if it's an alternative to identification, so I'm providing, I assume, more generally about business practices, but right now in my privacy policy, I tell if I'm a publisher or advertiser, I'm saying, kind of what my partners are doing with the data. And so it can't mean that. It's got to be something more, but it's not identification. So I think greater clarity is needed with respect to this, and I suspect that we'll probably get it. Global privacy control. This was an interesting development, which probably wasn't unexpected, but the statute says that there's optionality with respect to the global privacy control. in that that there is an alternative means provided between providing the opt-out or accepting the GPC. If you accept the GPC, then you don't need to provide the opt-out. The regs kind of, really try to narrow the bandwidth dramatically by saying that you need to provide and comply with the GPC if you have a friction-based experience, which I think most companies do have what would meet their standard of a friction-based experience. So tell folks, at least for now, don't get hung up on the legal nuance. If this is the way it ends up in the final regs, I don't know for sure. Just expect you're going to be complying with the global privacy control, or the opt-out preferencing, as they call it. Service providers. So service providers, the statute does not say that service providers cannot engage in cross-context behavioral advertising. What the statute says is that you can use personal information only as a service provider, only in a manner consistent with business purposes, and it lists about a half a dozen business purposes. There's an advertising and marketing business purpose, and if you use that business purpose, then you can't engage in cross-context behavioral advertising. I would submit that the proper read of the statutory provision is that the service provider can act in a manner consistent with whatever business purposes it elects to rely on. It's not a mandatory list, it's a permissive list. Can you use it consistent with short-term transient use? Sure. Could you do CCPA cross-context behavioral advertising with short-term transient use? Yeah, you can. It dramatically changes the nature of the CCPA that happens. It's much more truncated. Is it worth the is it worth the effort? I don't know. But all that being said, the draft regs say you just can't do it. So unless anyone is going to take that on, and I'm not really sure that it's worth taking on, because at least as I think about this in a multi-state context, like it probably puts California closer in line in alignment with some of the other states, potentially. So I'm certainly approaching this, at least from the IAB standpoint and our compliance framework, is that there will not be an opportunity to engage in cross-context behavioral advertising in service provider relationships, which frankly simplifies things. Then there are a host of requirements around what needs to be in service provider contracts, contractor contracts, contracts with your third parties. It is a fairly daunting list. These are all requirements folks are going to need to get into their contracts. We're going to put them into our IAB limited service provider agreements so that you can ride and have your agreements tick and tie with them, or they are provisions that can be relied upon for those scenarios where you do not have contracts in place. Some of those gap transactions we talked about, like with the ad servers as an example. And with that, I am happy to answer questions.
Okay, I'm going to kick us off here with a few questions. Thank you so much, Michael. This was beyond informative, and I know it was a lot of information for everyone, but as I've put in the chat, we are going to share the slides, and a recording of this will be made available. So well, I know it was a lot to take in all at once, and I understand that it's very valuable information right now. And don't worry, you will get a copy of this. You'll be able to review it on your own time. So Michael, to start us off, just kind of overall broad question here. How do you really foresee companies trying to harmonize their practices to address the various state laws?
It's And so from my discussions with multiple companies, and as I think about the issue, I see everyone has the wheels turning at the moment, and they're thinking about this in a couple of different buckets. So, one bucket, or there's really three buckets. First bucket is I'm going to identify the residency of the consumer. I'm going to do an IP lookup or whatever it is, which is always going to be an imperfect tool. And I'm going to deliver a very granularized state-specific experience. I expect that to hardly ever be done as an approach, but that is one that is theoretically available. Approach number two, which I expect will probably be the most common approach, but I do think there's going to be more than you think end up going into what's behind door number three. Door number two is I'm going to create two experiences. I'm going to create a California experience, and then I'm going to create another experience for all of the other states that have privacy laws. And so I'm going to need to do some sort of, IP address lookup, or do something that constitutes an effort to identify the location of the individual. And then I'm going to say, okay, California resident, I'm going to give them the opt-out of share, the opt-out of sale, the opt-out of sensitive PI, which is going to be different than the experience that's going to happen in the other states, where it's an opt-out of targeted advertising and for processing purposes, which is different. There's going to be probably an opt-in for sensitive PI across those states, I would imagine, is going to be your approach. You're probably going to look at all of the definitions for sensitive PI and aggregate them together to make sensitive PI its broadest, like combining the definitions across those 5 states. So I suspect that's probably going to be the most popular approach. And then there's the national approach. There are going to be those who will say, I want to treat all of my consumers the same. There are going to be those who are going to say, I don't have the technical capability to do all of this stuff. I need to give a single experience. However they rationalize their way of getting there, they're going to say, I'm not going to try to identify any individual who comes to my site to determine their residency. So now, and the folks who are thinking about this, they're struggling, honestly, about like how to achieve this. And I think of it as, some people said this, like, well, I need to find the lowest common denominator. No. You need to find the highest common denominator, right? What does that mean? Well, it means that you need to provide probably an opt-out for, you probably need to take like your privacy choices from California, go with that, you click through that, and then you're going to need to have an opt-out for cross-context behavioral advertising or targeted advertising. And whether some of this stuff has stresses against some of the prescriptive requirements that might exist in the draft regs, I don't know, but I think it probably could be pulled off. You would need to have an opt-in across everything for your sensitive personal information. And by the way, geolocation is now going to be an opt-in everywhere because some states have it as their sensitive PI. So, there's a dramatic business impact if you choose to go that route. But I do see that as what is behind door number 3 in a multi-state compliance. And then finally, I'll note, of course, we're putting together at IAB a multi-state industry compliance framework that's going to put together the right types of service provider relationships so that you can still do the measurement, the frequency capping, the advertising of first-party data, contextual advertising, and trying to cover off on those basic scenarios to keep the lights on.
That makes sense. Thank you. Yeah, I think it's gonna be interesting who's going to take that national approach, who's going to try to bifurcate, and what is that going to look like down the road? And no, that was super helpful, Michael. Thank you. Next question we have coming up is, how do you think of CPRA compliance impacting compliance in other states? And I specifically mean in the context of measurement services.
Yeah, so we can't really understate the impact of CPRA on the other states. Now, I start with a couple of premises. There are some who say, well, if I comply with CPRA, I've complied everywhere, right? Because CPRA has got to be the most stringent. That's actually fundamentally incorrect. There's an opt-in for sensitive PI in other states. The scope of targeted advertising includes processing, which is not necessarily included in the statutory language of CPRA. So you got to deal with it all on the same footing. But when I think about the impact of CPRA and the other laws, and I'll get to measurement because I'm going to actually answer a little bit broader. We've got this, I'll call it a weird dichotomy between sale, an opt-out of sale, and an opt-out for sharing for cross-context behavioral advertising, which has been transposed into other states for opt-out of sales and sharing for targeted advertising in the other states. How did we get here? Because of a huge amount of the shares, let's just say a large percentage of the shares for cross-context behavioral advertising, actually they're all sales, but there are certain sales that are not shares.
Right.
So this is a weird dichotomy. And how did we get here? Well, I think we got here because there were some bad decisions that were made. So in 2019, we had, these big debates, about the scope of the definition of sale. And, I told folks in the industry, I said, let's be practical about this. We all have our own legal interpretive views, but in my experience, I have never once seen a regulator interpret their statute that they enforce in a narrow manner. It will take on the broadest possible interpretation. Yet, sensibly, no one has rendered me the Supreme Court of the digital ad industry, and everyone, kind of came to their own conclusions. And I recently read an interview with Alistair McTaggart, and, he was asked about where this dichotomy came from. And he basically said that I saw some interpretations of sale being really narrow, which was not what I had in mind. So I changed it in the ballot initiative. And now that has been photocopied into all of these other states. And so that's how we end up where we're at now, which then takes us back to measurement. So measurement, I think everyone wished for a long time wasn't a sale. Now, intellectually, there was no reason to think of it differently other than we didn't want it to be. And now we've got confirmation from the CPPA that it is a sale. That is what we heard in one of the meetings. And what I heard from the California Attorney General was that he's looking for, sensibly, interpretive parity. So I expect there to be a parity in how state enforcers interpret sale, and that measurement is likely to be in it. So this is an example of sort of how we got to where we're at now, where measurement is within the scope of sale.
Makes sense.
And I'm also, by the way, Taylor, happy to also take on a couple of these questions if this is a good time to that I see in the chat.
Yeah.
So the first question, will the LSPA clearly identify all the parties in an individual ad sale? Well, in my dream state that there's a technological way to accomplish this. I wish I could snap my fingers and do this, but what I identified before, that technical challenge of even the ad getting delivered on the page, you don't even know who's going to be put in there, right? Because you got an ad agency that's putting pixels into the ad creative. So there's not really an easy answer to that. I wish there were. When do you think the new IAB privacy string specifications will be available. Well, I just handed over a nice package of the legal input to the IAB Tech Lab. I think they take up that work probably by the middle of July. I would expect, I can't speak for the Tech Lab. It's easier for me to say, sure, you'll have it all done. But folks are going to need to build to it. So I would imagine early fall seems like a reasonable time frame. Is there an argument that consumers expect targeted advertising? Isn't there an argument that consumers expect targeted advertising in today's society? Yeah, I mean, I think, and this gets to the new provision, right, of the draft regs about what a consumer reasonably expects. So, I mean, I think the answer is yes. Might be different, I guess, if you were in Europe with this rule. But I think the answer could be yes. But not all targeted advertising in all scenarios are created equal. And so one of the things that comes through in the draft regulations is that there are different scenarios, right? So listen, I go to a major publisher's website and I don't pay anything for the content. I expect targeted advertising. I get an app for a particular defined purpose. I'm not so sure that what my expectations are there. They could be different for the average consumer. So I think that's what they're trying to get at. Michael, for sensitive PI opt-in, what is your read on the use of standard mobile and browser permissions to use locations? Could we argue that those satisfy the requirement? I'm not 100% sure. Haven't studied it too closely, but I guess what I would say is this. One of the reads I take from the statute, and it's something that I spoke to yesterday at the Wirewheel Spokes Conference, is that there is an obligation for businesses to have a direct connection to the consumer's privacy election, and that it cannot be delegated out to a third party. So, part of the new sort of shiny object is can we engage in cross-site tracking on a network basis and, go to a third party page and get everyone to opt in, and then you're swept across all these publishers and ad tech companies. And, one of the things I articulated was that the answer was, I don't see how that's consistent with what it means for consent to be particularized. I don't see it as complying with the draft regulations. And the structure of the law, which is where I'm getting to, is that this law is different than GDPR. It acknowledges that the business has responsibilities to the consumers because they have a direct connection with them, as opposed to having all these joint controllers, half of whom in Europe, you don't know who they are. Here, you know who the business is. They have that obligation to directly provide you with your rights that needs to be honored. Can I speak to pending federal legislation? Not particularly. Well, to start with, I mean, I have slightly more insight than the average bear, but that is about as useful as I don't know what. But if I had to guess and say, and I don't speak from any authority here, and go with the premise, like all of you, I'm a lawyer, I'm pessimistic by nature. So do I think that there's going to be federal legislation passed? I don't think so. Have we made more progress than we've ever made? I do think so. It gives some hope for the future. And my feeling is this: by the time we all work like crazy to figure out how to reasonably comply to the letter of the law in all of these states in a multi-state fashion, as soon as we figured all this out, then we're going to get preemptive federal legislation. and it won't be till we put all the work in.
Thank you, Michael. Definitely agree there. This is the most progress we've seen, but it's hard to be optimistic. I think we have time maybe for one final question here. How do you foresee publishers approaching the requirement to recognize universal preference signals like GPC?
Yeah, so what I tell publishers is, this is part of the landscape, right? It is going to gain increasing usage among consumers. You're now required to accept the signal. Actually, you've been required in California to accept the signals. I mean, there's a gap, a technology gap that has thus far existed between what I'll call the requirement and like how it's supposed to be received. That gap is now going to narrow, right? It's in multiple state laws, and it's something everyone has a responsibility to comply with. And so, what does that actually mean now? When somebody comes to your page and they've got the global privacy control or the preference control enabled, you're going to need to communicate that internally within your databases. You probably have a privacy vendor that's working to facilitate so that you're not triggering information coming from certain databases that's going to result in a sale or a share. But you're also going to need to figure out how to communicate that. And that's part of our job at IAB and IAB Tech Lab, is to find the way to make sure that that is communicated. The technology mechanism, and I'm going to speak a little bit out of my depth here because I'm surely no product person or an engineer, just a lawyer. But I think it could happen in one of two ways: in a technical specification, like the global privacy platform that we're developing. One way is to say there's a slot for GPC, and you would have an obligation to repropagate that GPC election downstream. Then there's the second way, which to me as a lawyer seems like the most logical way, but that doesn't mean it's the right way from a technical standpoint. The way I view it is, when someone has GPC enabled, when they come to your site, it's no different than someone having pressed the opt-out button. You need to treat it exactly the same way. So what you need to do is work with your CMP to encode the string where you have an opt-out in no different manner than if someone pressed it on your page. For the folks who are downstream who are receiving the signals, I don't think it matters from a legal perspective or a business perspective whether the consumer made the election on the page or using the global opt-out tool.
Makes sense. Yeah, there's no differentiation there. But all right, Michael, this was amazing. Thank you so much. And thank you to all the participants who were able to make it today. We will definitely be sending around the materials, and we appreciate everyone coming today. Thank you so much. And thank you, Michael.
Happy to be here. And thank you so much for inviting me.
Of course.